Here. We have a great webinar today. Probably one of the most important webinars you can watch. Employment contracts, right? And it's one of those things. You might have employment contracts, but they might be old. You may not have employment contracts, which is not good. I was just thinking, Darcy, it's like imagine having a professional sports team, right? And not having employment contracts. Imagine the chaos that would create. People just jumping from team to team, nothing to follow. So it's it really is an applicable topic. It's a really, really important topic. I'm not an HR guy, but I always know that I always say, the handbook, the compliant policy manual, and the employment contract are such important things. So now that we're all good to go here with Darcy, we are going to begin. Same format as normal. Darcy's going to give a presentation and then Q&A. You can send questions. Just a heads up, we get a lot of questions, and these days we have a hard time getting to all of them. I do try to triage it and get to the ones that are, try to minimize duplicates, but send your questions in as we go. It is being recorded. It will be sent out on Monday. And like all of our webinars, they live in our HR hub. So I will stop talking and hey, Darcy, you get a new shirt?
No, this is my oldest of shirts. Like this goes back to my LinkedIn profile. So this is like Throwback Thursday.
Okay, nice. Well, it looks good. I decided to go with the no dress shirt, all black look today. But you look very handsome in that blue shirt. So with no further ado, Darcy, over to you.
I can't take any more of the flattery, but thank you. Thanks, Brett, for the introduction. And thank you, Sony, behind the scenes. Welcome, everybody, to the presentation today. I'm going to throw the presentation up while we're chatting. This is a great topic. It's one of our most popular topics. For the reasons Brett mentioned, it's just because of the sheer importance of the employment agreement. It is the nexus for everything. This is one of those presentations that I can literally do a 2-hour presentation on and still have time to keep on going because of all the nuances that are required to be investigated in an employment agreement. So I'm glad everyone's here. We had a great turnout, and we see people still funneling in. So as you know, for the people that have been here, I talk relatively quick. It's being taped, as Brett said, so we'll get it out to you after if you need to slow me down. I haven't even had any coffee yet today, so that's great. So we're going to jump right in because I want to try and get this done in 15-20 minutes so we can actually have lots of time for Q&A, because my understanding is we already have about 20-30 questions already submitted. So the importance of the employment agreement. You just got finished, me and Brett as well, telling you how important the employment agreement is in the overall life cycle of the employment relationship. Here's a couple of reasons why. One, it provides you with flexibility, right? So when you sign an employment agreement and you sign, and it's not just that having the employment agreement, it's the fact that it's well drafted, it's well written, it's able to be well implemented. When you sign an employment agreement and you have employees that you have different locations, like, so let's say you're a restaurant or a retail and you have to move people from different location to location, every time they move from one location to the other, if that's not named in their employment agreement, or they have a home base that's named in their employment agreement, when they go anywhere else except the home base that's in their employment agreement, they need to get paid both time and potentially kilometers, depending on how your employment agreement is worded. So it's really important. The other big key thing, and this was out of COVID, and it was a learning lesson for a lot of employers and HR people alike, layoffs. It is illegal. You cannot lay off somebody in this country unless it's specifically named in your employment agreement, or you are one of those industries where it's an expectation, like fishery or something that's truly seasonal. There's some exceptions for that across Canada, but unless you have that that layoff language in your employment agreement, which provides you that flexibility to answer to operational needs, the marketplace being what it is, you're out of luck. So it's really important to capture that. Policies and job descriptions, this is a double-edged sword, but at the end of the day, your policies by themselves, if you're not giving your policy manual to your employees before they start, or you're not having something in your employment agreement that assigns the policies as part of the employment agreement, your policies do not become conditions of employment, which means your policies are inherently less enforceable than they would be if you reference them in your employment agreement. So this is the one opportunity you have to do that, right? I unfortunately, we just had a client who's going through a policy review, and this just happened today, and it's fresh. Is going through a policy review, and there's a few employees that are refusing to sign the policy manual. To their credit, to the employee's credit, they legally are not required to do that, right? You can, it's like signing up for a mortgage or signing up for a car, and then after you signed up to buy the car or the mortgage, then they give you all the terms and conditions after. Doesn't work that way. So there's ways we can help that client, but for you, if you do your employment agreement right, it's not something you have to worry about. Define different types of employment. This is super important. We're going to go into this in a little bit more detail in this presentation. Management versus non-management, exempt versus non-exempt. And some of you might not know what that means. We'll touch on it. Salary versus wage, temporary versus permanent. All these different things, they must, crucial, critical, must be in your employment agreement. It's the only place you get to define it. We get this question on average, and we get hundreds, sometimes thousands of questions in a week amongst our advisory team. But we probably 10 to 20 times a week, we get this question from every jurisdiction across Canada. What is a full-time employee? What is a part-time employee? What's a casual employee? Employment legislation does not define that, right? Usually it's a benefit question, and that's why people are asking. And your benefits policy or your master benefit booklet will define what is a full-time or a part-time employee for the purpose of eligibility for the benefit plan. But employment legislation does not define which is what. It's up to you and your employment agreement to make that definition. Okay, preconditions of employment. Again, super important. We're not going to touch on this. This will be the one time I kind of speak to it, maybe in the next slide a little bit. But at the end of the day, whenever you give an employment agreement, if there's things that you need to be able to qualify before they can actually be able to do that job, but you need that person now, you could put in preconditions of employment. For example, if you have somebody who's working with cash, right? You're going to want to do a criminal background check. If you have somebody that's going to have to drive for a certain aspect of their job, you're going to want to do a driver's abstract. So you can offer somebody a job with a precondition of employment, which states we require a suitable criminal background check or a suitable driver's abstract in order for you to continue on doing this job. And once we receive it, that condition has been satisfied, the employment agreement can commence. If we receive it and it's not satisfactory, we can end the employment agreement. Doesn't cost us anything. You have no case. But if it's not in your employment agreement, that's a problem, right? That's your one opportunity to do that. And most importantly, I left this slide at this point to the last for a specific reason. This is an employment agreement is two things and two things most. It's one, your leverage. It is the one opportunity that you have to dictate terms to the employee. I know if some of you follow social media and on LinkedIn and what have you, we try to, engage people with our, posts leading up to webinar. One of the posts I put in there was about leverage. And at any point during the employment agreement, because keep this in mind and make no bones about it, the employment agreement, once signed, is a legally binding document, not just on the employee, on the employer as well, which means you can't go back and change it without liability or costs, right? You cannot go back and unilaterally change that employment agreement without liability or costs. That'd be like going to your credit card company and saying, you know what, I've been doing this for a year, I want to pay 10% less interest. Doesn't work that way. And they can't do it to you either, right? They have to provide notice or saying there's things you have to do, all this kind of jazz. But for you, this is the one time where you get to put everything you want in it. And if they don't like it, too bad, you don't get the job. And it's as simple as that. Right. And when we're in a decent market, when we're in an employee friendly market, that's a little bit more complicated. But the market we're evolving into finally is starting to find a little more leverage for employers. So we're not in a bad spot. We could actually say, hey, here's the terms and conditions. If you like it, great. If not, we can find somebody else. That's where we're moving towards greatly in the market, which is awesome. The key point there is, and I know there's some people that disagree with this, and I would strongly argue on my point of view, the employment agreement is 100% for the employer, right? So when you have these people that say, oh, I want a simple employment agreement, all this kind of stuff, I don't want 7 pages. I go, dude, this employment agreement is for you. Like this isn't to make it easy to bring on this person. This employment agreement, everything in that employment agreement is to protect you. So why wouldn't you make it as thorough and as, precise as possible? So the construction of an employment agreement, it's pretty basic in its essence. but I want to go through it just for those people, especially those people that only use employment letters or employment agreements that are 1 to 3 pages long. It's important that you understand what you're missing. The proper construction of an employment agreement, if you see something highlighted in red, that just means we're going to touch on it a little bit more in this presentation. I can't cover everything. It's like I said, if I did a micro on this, it could be 2 hours of a presentation and we'd still have lots of questions. But I could absolutely cover a couple of important things, which are, in my experience doing this for a minute, are the questions we get asked most by our clients, which means you have those questions as well. Employment status, method of payment, qualifications of hours, location and working arrangements. All these things are the one opportunity. If you don't define them in the working relationship, one of two things happen. Either one, it's defined by precedent, which means how you work once you get into it after a year or so, those things become the norm, they become accepted, they become contractually binding kind of terms of employment, even though it's not written down. Or two, the employee will have the right, based on falling back on the ESA or the ESC, to call you to it. Call you on it. Basically, you on all of these things, you fall back to common law or civil law in Quebec. You are no longer your contract is in essence a lame duck, right? So those things are important. Types of employment, we've already talked about this briefly. Permanent, fixed term, seasonal, that needs to be referenced in your employment agreement for clarity, just so you understand what type of employment relationship it is, especially when you get into things like seasonal or fixed term. We'll touch on it briefly later on when we talk about the legal pitfalls of employment agreements. But if that's what that employment agreement is, a fixed term or seasonal, it needs to be noted. If it's not noted, the law automatically defers that contract to a permanent contract, right? Even if it's not your intention, if it's not noted what kind of contract is, it becomes permanent. Unless you have an end date, but that's stipulation. Preconditions of employment, we've already discussed that. Those are the things when you've asked for things in advance and say, if you can satisfy our requirements on this, we'll make this a permanent or, this an enforceable employment agreement. Cement your policies and contractual and JDs. I'm not going to talk about it except for this one thing. Job descriptions, and that's why I put is a preference. Job descriptions is not something a lot of HR people, a lot of business people, even employment lawyers, our employment lawyers are an advocate of this, and that's okay. That's why you have two different points of view. But our employment lawyers and other lawyers and HR people are in employment of having the job description as a term and condition of employment. The problem for me is that over time, job descriptions evolve. Jobs change, and it happens organically. It doesn't happen purposely. If it happens purposely, that's easy. You make the changes to the job description, you make the changes to, the job, the employment agreement because it's referenced there. That's fine. But when a job description happens organically, or job description changes organically over time, if you go back and renew and refresh your employment agreement over time, that employment agreement has the effect of becoming stale, which means it's no longer enforceable. That's why I like to refer to a job description, but have the job description as a separate and distinct document, which you can change without having to change the employment agreement. But again, there's no right or wrong answer. It's a matter of preference. So a lot of lawyers, HR people, business owners, what have you, like to have the job descriptions there, which is why I referenced it in the presentation. Important terms, again, I could do an hour on this all by itself. The layoff clause, which we referenced already. Severability, which basically means that if one part of this employment agreement is not enforceable, the rest remains. Confidentialities, non-disclosure agreements, injunctive relief, renew and refresh. All these things, these are the things when you have a 7-page agreement and my client is saying to me, Darcy goes, I only need like 2 or 3 pages. I don't need all of this language. And I go, yeah, you do. Yeah, you do. That's what this is in part, right? This you don't realize how important it is until that one day, like I said in one of our social media posts, when you have an ex-employee who starts poaching all of your ex-clients and starting to, actively recruit your employees, and you go to your employment lawyer and say, what can I do about this? And they go, did you have a non-solicit clause? That big long clause that took 3/4 of a page that you didn't want because that made it easier for the employee to understand. Oh, no, yeah, I didn't do that. I just thought it was not necessary. Well, guess what? Now you're losing all your clients. There's not a damn thing you can do about it. So it's really important that even though there's a reason why, well, there's a couple of reasons, but there's a reason why lawyers exist in this world. This is one of them, and it's a good thing for employers. Restrictive covenants, super important. Non-solicit, just was speaking to that. Non-compete, in some provinces it's illegal, in some provinces it's not. We'll touch on that. But termination clause, that's the forever moving thing. Right? If you have not reviewed your employment agreement, and every time we talk about it, I always say it, And I'm not saying it because I'm repeating what I said last time. I'm saying it because it keeps on changing. Even as much to as this calendar year with the three or 4 months ago, there was a big piece of case law that came out in Ontario, which will apply to all. Probably you've already starting to see it applied in other jurisdictions because these type of case law travel, which basically changes effectively the way 90 to 95% of termination clauses written in this country are enforceable. So if you have not had your employment agreement reviewed within the past ruling year, there's a better than average chance your termination clause is not enforceable. I am going way too slow, so I'm going to go faster, which hopefully I'm just going to be more contrite, and I'll try and get this done within 9 minutes max. Employment. So this is important. I unfortunately had this another. Anyways, I won't go into it. Salary is not a status. Salary is simply a method of payment. It's nothing more. When you pay somebody by salary, that does not mean that they are exempt from overtime. That does not mean that they can work 50, 60 hours a week and that's the money they receive and nothing more. Okay. It's important to understand it's one of the biggest misnomers with employment contracts. The term salary is only a method of payment. It does not define the status. What does define the status is whether you are exempt from overtime or non-exempt from overtime. So exempt versus non-exempt in almost every jurisdiction, with the exception of maybe 1 and 2 with a qualifying period. What is the largest group of people that are exempt from overtime are people that are considered managers or supervisors. So if you are considered a manager or supervisor, then regardless of whether you get paid by hourly, salary, piecework, what have you, you are exempt from overtime, which means you can work but you don't get paid. Even if you got paid on an hourly basis, but you're a manager or supervisor, you can continue to get paid after 44 hours or 40 hours, depending what jurisdiction you are, but you don't get paid a time and a half. Right? If your salary, you get paid your salary. That's what it is. The most common exempt, I just said that. And in order to adhere to that rule, by the way, in almost every jurisdiction, I'll name the couple of famous cases where this happened. You have to do managerial duties 50% of the time. So we have circumstances where, for example, one of the big lawsuits that happened in Canada, this is years back, where they talked about mortgage managers or mortgage specialists and all these kind of stuff in banks. When in fact, the Ministry of Labor or Labor Board respectively came in and looked at it, they said, yes, they do have managerial responsibilities. Yes, they do have supervisory responsibilities. But more than 50% of the time, even though you gave them that title and you're paying them a salary, not giving them overtime, more than 50% of the time, they're filling out the paperwork just like every other employee. They're sitting down with the clients just like every other employee. So even though you call them a manager or you give them a portfolio, more than 50% of the time, they're doing employee work. They're not exempt from overtime. Even though they're getting paid salary, they are a non-exempt employee. That cost that bank, and I'm not going to name the bank, that cost that bank almost $2 billion, $2 billion with a B, dollars in back pay. And lost wages and what have you, vacation pay that would be paid back because you get paid vacation on all the wages you earn, et cetera, et cetera. It's an expensive lesson to learn. All of that aside, one of the most important lessons that gets overlooked in employment contracts. Tell me if you read the difference between this when you do pay somebody on salary, right? Because there's a lot. I catch this at least a couple times a week when I review employment agreements for clients. You will be paid a salary based on 40 hours a work week. You will be paid a salary based on an average of 40 hours per work week. That average means the difference between a person working 50 hours and you only having to pay 40 hours, and that person working 50 hours in the first example, but because you specifically say your salary is based on 40 hours, you do not put an average. You do not put may sometimes. You do not qualify the 40 hours at all. It says you get paid a salary based on a 40-hour work week, which means for every hour they work over 40, they are entitled to pay. There's no way around it. It's semantics, call it what you will, but it's what it is. So it's really important to review your employment agreement from that lens. And the employment agreement should surely state conditions around pay. So in other words, another big thing you'll see with salaried employees is, and I just had this 3 weeks ago, had a salaried employee, the client called me up and said, listen, this person's been off for 2 months. We stopped paying them obviously because they're on EI, but now they're suing us for that 2 months pay. And I go, did you have something in your employment agreement that says that they have a specific amount of sick time that's included in their salary? If it's moot, that means the employee can infer that when they're off work, even on sick time for 2 months, that their salary continues. So it's really important to stipulate what is included in your salary. Termination clause, we'll go through this quickly. I'm going to get these next 2 slides done in 5 minutes, promise. Limiting entitlements. So these are the legal, you should ideally, like even myself doing this for a while, when I look at a termination clause, I know what to look for. Like I know exactly what I should, I can look at something and tell you whether it's void or not void, enforceable or not enforceable. But even nowadays, I will defer to our great lawyers and say, Anatoly, Babisa, Tom, can you please take a look at this employment agreement? I do not think this is enforceable, but I want you to take a boo at it. That's how complicated it's been getting, right? So it's important. You must limit the entitlements. There can be no ambiguity. Okay. It has to be specific about what they're entitled to and what they're not entitled to. You simply can't say you are entitled to everything that you would be under the employment legislation in your jurisdiction. You are entitled to anything in the statutory notice period that is really the ESA or the ESC. You have to spell it out. You are entitled to benefits. You are entitled to compensation. You are entitled for that period of time in Ontario, for example, whatever you are entitled to when you get terminated and you have 2 weeks pay and work. So they're not working. They're going to get 2 weeks pay in lieu of working notice. That's a statutory requirement. Anything that they were entitled to during their time working there, they're entitled to during that 2 weeks. And if you want that termination clause to be enforceable, you have to specifically say that in your termination clause. It has to be non-ambiguous. This is recent. I did talk to this client. They gave me permission to actually use this as an example. And their employment agreement was actually drafted by a lawyer, which is, it's what it is. That's why they have 2 lawyers in a courtroom, because that means one of them is wrong sometimes, or just seeing it from a different angle. Not necessarily wrong, just there's always two different interpretations, versions, applications of any law or anything of that nature. But in this case, you'll see here, because these termination clauses, and this is from Calgary, so these are relatively recent, but the actual nexus for these came in Alberta, followed in Ontario, then BC. So this is everywhere. Right? This is everywhere. So basically it says, when you see in your termination clause, it says something like this: an employment standards legislation will pay you, if we terminate you, we'll employ you the employment standards legislation and as such notice as company. However, in our sole discretion, we can provide more. Or in the next one, we're going to terminate you 60 days or more. Whenever the way the courts have looked at this, whenever you put a sole discretion clause in your termination agreement, so you say, we can provide you this, and this is all you're entitled to, but if we feel like it will provide you more, the employee has the right to infer that they're entitled to more. They can't go in. The whole idea of a termination clause is they have to know what they're going to get and what they're not going to get. If there's any ambiguity whatsoever, the court will rule on the side of the employee. Okay, so even if you don't want to use an HR person or an HR lawyer, go take a look at your termination clause and see if there's any discretionary language in there. If there's discretionary language in there, your employment agreement is likely, or your termination clause is likely not enforceable. Ontario specific, the first one though, travels. Okay, so the first one crosses borders. Wakesdale versus, this is a few years old now, but I have to mention it because it's that important. It's the law. It's the case law that says you must view your employment agreement or your termination clause as a whole. So if you terminate somebody not for cause, for example, and the judge rules that your termination not for clause wording is pristine, it's money, like there's nothing wrong with it whatsoever. But then they go back and look at your termination for cause language, which is the case in the Wakesdale case, and they found that the termination for cause language was not enforceable, that it was a violation of the ESA, even though they didn't terminate that person for cause. They terminated them not for cause, and that wording is great. The judge ruled you literally have to throw out the baby with the bathwater, as they proverbially say. If one part of your employment agreement or termination clause is not is void, then all of it's void, even if it's not applicable in the case. So it's really important that most of the time it's the not for cause language that has been explored as being, not enforceable, what have you. But since Wakesdale, it's forced lawyers and HR folk to go back and say, okay, we have to look at our for cause language too. We just defer back to the ESA or the ESC. That's not good enough. You literally have to go back and examine it and make sure that it's all enforceable for the termination clause itself to be enforceable. The render one was specific to Ontario. In Ontario, when you terminate somebody and you want to have to pay them nothing, you need just cause, which is basically meaning the employment relationship is untenable, it's not trustworthy, etc. But you also need willful misconduct, which means the action in which the employee committed was considered to be not only egregious, but intentional or deliberate. So basically this said that you can separate the two. It's always been deferred that you have to have both bars. The reason this was a problem is because this is a person of 8 years that, it ended up winning over $100,000 award, but not quite, sorry, that was the other way around, not the case, but ended up winning a very significant award, and they terminated him for just cause and willful misconduct. They said that even though his action of touching a woman's buttock and that's what it was. He touched a woman's butt. And he was a senior person in the organization, was definitely egregious and worthy of just cause termination. They deemed it not to be intentional or deliberate. It was a spur of the moment thing. Don't even get me started. I can't justify it. I don't want to. But that was the big separation. This is the one I was talking about at the beginning. It's important. It's important for everybody because I'm talking about 90 to 95% of a termination for not either probation language or termination not for cause language, benefit language. Whenever you see anything in an employment agreement that says we may terminate you at any time, within the probationary period, we may terminate you at any time. We can get rid of your benefits at any time. Wherever you see that, that means your employment agreement or that particular clause is potentially unenforceable and or void. The reason being is it's a violation of ESA in Ontario and ESC in other provinces like British Columbia, where they basically say you can't terminate somebody when they're on a statutory leave. You can't do that. They have job protections. So you having language that says we could terminate you not for cause at any time is actually a violation of the Employment Standards Act or code, which makes that termination clause void. I guarantee you, if there's 103, I think there's 300 people on this call. If there's 300 people on this call right now, 280 of you, if you go back and read your employment agreement, somewhere in there in one of your clauses, it will say at any time. That's why this is important. And of course, if you want to understand the logic for all of this, it's pretty simple. Oops, sorry. I didn't want to do that. I don't know how to go back. Can I go back? Hey, technology. See, I was really late for that meeting. But the logic for all of this, just so you understand, and this is a pitfall of employment agreements, this is the way the courts view it. We live in, with the exception of Quebec, all of Canadian jurisdictions are common law, which is the theory of fairness and equity. So the courts have taken on this torch on behalf of employees. They realize that employees have less bargaining power than employers because we're offering the job, we're offering the money, right? We can go find somebody else if we want to, and that's our right, right? So the courts realize that. They also realize that most employees are not aware of the employment legislation and how it applies to termination clauses and things of that nature. So even when they do get terminated, they will not necessarily have the resident knowledge to sue the employer to, get justice, because the courts are proactive about it. So that's why the courts are so favorable against termination clauses. Finally, and I'll do this super quick. I know I keep on saying that. I'm over my 5 minutes. I'm sorry. These are the things you need to be aware of in employment agreements. You have to give reasonable time to review and sign back in advance. If you don't, if it's a longer employment agreement, like an executive or management employment agreement, and you don't give them at least 5 days, it's not necessarily an enforceable employment agreement. At the very minimum, everything in it must be to the standard of the ESA or the ESC. I already talked about the courts not being looked favorable upon clarity around hours and pay and status. We talked about that. Renew and refresh. Again, if your job descriptions change over time, if laws change, if case law changes, if employment legislation changes, you don't have a renew and refresh clause in your employment agreement, that means you can't just automatically go and renew and refresh and update it and not provide consideration. You would actually have to go renew it, refresh and provide a new agreement, and then provide consideration in turn. That could get expensive. And then temporary agreements. Just keep in mind, temporary agreements are relatively dangerous. If you don't have an end date on them, for example, they're not a temporary agreement, even if you think they are. Okay, if a temporary agreement has an end date and it goes even one date past that end date, it's automatically considered a permanent contract. So all these things are really important and be something you should be looking for in an employment agreement when you construct it. Again, I apologize for the rush. I could do a lot. We could talk a lot longer about this. Oh, there we go. Us, HR covered. We do it all. Like a lot of our clients are here today and we appreciate you keep on coming back. We're glad that you like the webinars and we'll continue to do them for you. If there's ever a topic that you want us to talk about, please email it in. I guarantee if it's even more than one of you, we'll do the topic because we know there's more of you out there that will like it. But this is everything we do. All of our memberships that we have, which are great. We have consulting, so we can do anything you want, even if it falls out of the scope of our membership. We do recruitment, and we have the only legal product in Canada where you can pay one price and get unlimited advice from our employment lawyers. It's awesome. They work in conjunction with my HR team. We work really well together, and it's a great bow on everything that you need to be ensured that your HR and employment law issues are being handled in-house really well for a really good value. Thank you everyone for attending. That's my dog Tar Heel. He's here right now. He's being quiet, which is awesome. I'll turn it over to Brett for questions. Sorry for going so long.
Well, you didn't go long at all. It's only 2:30 Eastern time.
Good.
You take a deep breath there, Darcy.
I'm trying.
Endurance. That was great. A lot there. That was 45 minutes of information in 25 minutes. So I think we set a world record there, or you set a world record. So let's jump into the questions. You got yourself a glass of water? There you go. Nice. There you go. Stay hydrated. Okay, let's get into it. Lots of questions. First question. We would like to have our employees sign new employment agreements with updated terms. How do we go about doing that?
Good question. We've been getting a lot lately because of the changes you mentioned, and we'd like to keep our clients informed. So when we do send out the employment agreement, we let them know that when you get somebody to sign a contract, both parties have to benefit. So obviously the new terms, you getting to sign the contract, the employer is benefiting. So the employee has to benefit as well, which means you have to give them consideration. Consideration is anything of value to the employee. It could be a box of cornflakes, right? If the employee says that the value to me and you offer them a box of cornflakes, they can take it. But realistically, in most cases, consideration for most employers and employees, small pay raise, a day off, a pizza party, whatever, a gift card, if it's a small change. It's interesting. Like if the change is meaningful, like if there was a change that actually really impacted the employee, they might require more in the way of consideration, but the courts don't define what consideration is. So it's really an issue of you getting together with your employees and bargaining what you will give them and what they value in exchange for signing the new employment agreement.
Makes sense. And I guess to be safe, offer something that you feel is fair, because you don't want it to go to court and then they're like, well, you didn't really offer anything that was fair. So kind of always, is that true?
Yeah, no, my fear is this, because you touched on a really awesome point in my opinion. My fear is this, is the courts have neglected to weigh in on what appropriate consideration is. My belief is that when you enter in an employment agreement, they respect the right of both parties to bargain for what they think is fair, what both parties think is fair. And I think signing a new employment agreement is an extension of that process, that they don't want to get in the way and dictate to employers or employees what appropriate consideration is. The more it happens, though, I think someday the courts will try it. I think one day a lower court, and it'll get to a higher court, will start to deem that, okay, you took an employee that had no kind of termination clause, which means right now, after being there for 10 years, they're probably, entitled to 10 months common law. And you're going to say you have to sign something that says they can only get the ESA minimum, which is 8 weeks. And then you offer them a $2 raise. A court's going to say that's inadequate. At some point, I believe that to happen. It hasn't shown its face yet, but that's why I think, like you said, Brett, you're wise to be fair. You never want to be that first one that ends up in a court or in an arbitration, for that matter, if you're unionized or had that arbitration clause in your employment agreement, which is a thing, and be the first one who gets tried and tested on that.
We provide a pretty simple offer letter. When we terminate someone, we include the requirements around confidentiality, non-solicitation, etc. In terms of the termination letter, is that suitable?
So you provide it. If you provide a simple offer letter, in other words, it's void of those things that you're talking about, non-solicitation, non-disclosure, et cetera. When you provide the termination letter, they're not obligated to abide by any of those things. You could offer them money in exchange for them to sign this release, which contains the non-disclosure language and the non-solicitation language and all that kind of jazz. But if they just want to say, nope, I'll just take my ESA or ESC minimums, and now I'm going to go poach all your clients, you have no legal right to enforce anything. The employment agreement is the place where you do that. You could try to get it at termination, but it's going to cost you, one, and two, the employee has no legal obligation whatsoever to abide by any of it. So it just would seem folly to me to put that on the back door where there's conditions and contingencies on it, as opposed to the front door where you can dictate it.
Yeah. We have a performance management language that we include in our employment agreement. Should there be a policy or both? Should that be in there? Should that be in there as a policy or both?
Which, sorry, Brett, what was the start of the question?
We have a performance management language
okay.
we include in our employment agreement. Should that be in a policy or in both?
In my opinion, again, you would have caught it with the job descriptions. My opinion of this, and again, it's not a right or wrong. It's a matter of perspective, and it's the way I look at things. Anything that is organic, anything that can change, anything that you might want to change in the future, you do not necessarily want that in your employment agreement. Okay, so with an performance management program, you might say, okay, if it's generic, we have a performance management program tied to, compensation. Something as simple as that. If there's ever a case where you are not doing great as a company, and then someone does really good on their performance management plan, which you've committed to in your employment agreement, and then because you can't afford to give them a raise, they can claim constructive dismissal. You put that in your employment agreement, right? Like you put that in your employment agreement. So even if you have a performance management plan, because I've seen these before where the performance management plans and the details about it are more, defined, we will give you a review at 3 months. We will give you a review on the annual, et cetera, et cetera. And then, 6, 7 months goes by and you haven't given that, review. And then a year goes by and you still haven't given that review. There's a basis. I'm not sure if you win on this one by itself, but there's a basis for constructive dismissal because you committed to that in your employment agreement. When there's operational things or things that are organic, in other words, things that can change or you may want to have change in the future, I encourage you to reference that we do performance management in your employment agreement, but I don't encourage any more detail than that. It should be a separate, distinct document that you can change without having to change the framework of the employment relationship, which is the employment agreement.
Okay, next question. What's the difference between a non-compete clause and a non-solicitation clause?
We're getting that a lot lately, and ironically, it's coming from in Ontario. If for those who don't know or are out of jurisdiction in Ontario, non-competes are no longer legal or enforceable, so you cannot include them in employment agreement. If they existed in your employment agreement at a certain point, they're still enforceable, although they mostly get shot down. We have lawyers that are actually like employment lawyers that are actually challenging us on this all the time, and it's not complicated. They're just, unfortunately, they're reading the legislation wrong. A non-solicitation basically says that you can't solicit clients, you can't take our proprietary information, all these different, you can't use our logos, you can't, disclose our pricing, all this different stuff. It's not prohibiting you from working in your industry. It's not prohibiting you from working for any length of time. It's not prohibiting you from making an alternative means. It's just, you can work elsewhere. You can either work for a direct competitor. You just can't do these things which are confidential and proprietary to us, including our client list, including our employees. There's a big difference between saying, you worked here and we made you privy to these things, and now we have the right to hold on to them for a year or two, and saying, you can't work anywhere in our field for 1 year within 200 kilometers. That's a non-compete. This is a non-solicit. Non-solicits for all you employment lawyers. So I know a lot of you, there's a couple of you that are not that I talk to on the other end of the phone, that come and watch some of these things, I've been told now. So if you're on here, just so you know, I'll fight with you about this all day. A non-solicit is not a non-compete, and non-solicits are enforceable and a highly valuable tool in every jurisdiction in Canada.
Okay.
Fighting words.
We are an American company with locations and employees in Canada. Can we provide them with our American-based employment agreements since we're based in America?
We have a lot of American-based companies, and more as we go, and that's happened since COVID and the mobilization and movement of employees. The answer is no. It's a good question because there might be a couple of people out there, and it goes both ways. The jurisdiction, with a couple of exceptions, I think the exception is BC. The jurisdiction in which an employee works is the legislation that they are governed by. So even if you were an American company and you have somebody, and because another thing American companies that we have came to us with was they had a Canadian agreement and it covered every jurisdiction. Every jurisdiction is different. You need an employment agreement for every single jurisdiction. If you're a Canadian company out of BC, for example, and you have employees in Alberta, or sorry, let's say, to make it easier because BC is the one with silver, out of Manitoba, and you have employees in New Brunswick, Quebec, Ontario, BC, Alberta, you need different employment agreements for every jurisdiction. An employee is governed by the jurisdiction in which they live, not by where the head office is that puts the address or where the pay comes from. So that's super important. In addition, with US employment contracts, they're a completely different animal. A lot of states have at-will employment, which means they can fire you for no reason. That's one of the things that when we've encountered it, a Canadian employee that had at-will language in their language, it voids the entire contract because it goes against the spirit of the contract and common law itself. So even if you had a severability clause in it, the whole contract is void. It's not enforceable. So long answer, short question. Sorry.
Okay. Hey, one question that I have is in terms of, and I know every jurisdiction is different, but what would you say, let's say you had an employment agreement in province X that was done, 3 years ago or 5 years ago. At which point should you have it reviewed again to ensure that it's still enforceable? Because I know you've talked about a lot of things changed since COVID. Is there a number or if it's like, hey, if you have an employment contract that's over 3 years old, you should have it reviewed. Is there kind of like a rule that you have?
Yeah, and a lot. It's a great question in so much as that, like, let's say you're with HR Covered, and I'm going to be biased here. I'm going to speak to what we know. If you're with HR Covered, if there's major changes to your that would affect your employment agreement, we let you know. So in a case like that, a good renew and refresh clause that you would have in your employment agreement typically is 3 to 5 years, because in 3 to 5 years you could capture a lot of changes. Your job descriptions might change, job duties might change. You might have given that employee a raise or a bonus. You can capture that all in a renew and refresh every 3 to 5 years. If you are, and that's if you have someone like us or another HR firm or an employment lawyer who keeps, or you're diligent yourself, who keeps abreast of all these different changes. If you're not having someone if you're not that diligent, if you're focusing on the business you do and not HR, which is most companies, or you don't have an HR person or an employment lawyer keeping you up to date, you really should be looking at it every year, right? Like, we'll catch it for you. Your employment lawyer will catch it for you. Your expert HR person in-house is going to catch it for you. But if you don't have that person, you really need to look at it every year to make sure that there hasn't been any significant changes. If you do have that person, 3 to 5 years. 3 years is best practice, in my opinion.
We don't pay overtime, but rather pay time in lieu. That can be used as a pay time off later. Is there an issue with this, and should this be in the employment agreement?
That's a good question. Legally, you have to have a signed agreement with your employee to say, we're not going to pay you overtime. We're going to give it to you time in lieu. So there has to be a signed agreement. If it's in your agreement that, for example, I'm just going to throw out awkward wording in there. Rather than pay overtime, we pay time in lieu, a time and a half. This is an acknowledgement that you have the right to collect the overtime. However, you're agreeing to taking a time in lieu to be used on a date within the prescribed timeline within the jurisdiction. If you put that in the employment agreement and they sign the employment agreement, that serves as the agreement. But there was a couple of important points in there. Even if you have that signed, overtime in almost every jurisdiction, not every, there's 1 or 2 out there that you could do it straight time. In most jurisdictions, overtime, when someone reaches that 40-hour or 44-hour threshold and they get that time in lieu, the time in lieu must be a time and a half. So they're not just getting 1 hour for the extra hour worked, they're getting 1.5 hours for the extra hour work that was overtime. That's important. The second important thing is, in every jurisdiction, there's a stipulation by which that time must be used. So in Ontario, and I think BC as well, they're very similar about their employment legislation. When you get a time in lieu, it must be used within 90 days. If not, you have to have an agreement. You either have to pay it out, or you can have an agreement with the employee that time in lieu can be extended for a year. For those employees, like we're getting this. I'm going to jump into a little side topic because we're getting this question already. We have a lot of clients who have Christmas closures. Some do pay for their employees during Christmas closures. Some don't, right? So they just have a week that's unpaid and they can use vacation or they can go unpaid. Time in lieu is a great way. If you pay your employees overtime, time in lieu banks are a great way to allow your employees to subsidize for that Christmas closure so they can have pay over the Christmas holidays. Just it's a value add that I'm mentioning now just because it's the season, or we're coming up on the season anyways, after November the 11th.
Okay. Our agreements do not state a specific number of an average number of hours expected to work in a week for their salary. Is this good or bad for us?
It can be good. It can be good because if they're management, you're fine. And it doesn't state a specific amount. It's just said you're expected to work till you get the job done, and you're a non-exempt employee, or sorry, you're an exempt employee, which means you're not entitled to overtime. That actually it's not a bad deal. It can work for you, but it goes both ways. That also means that if the employee works 20 hours in a week and you're basing your salary on the average of a 40-hour work week, they get paid the 40-hour work week even if they only work 20. So you have to know that if you're not going to be clear and stipulated. Now, if they're a non-exempt employee, meaning they are entitled to overtime even though you think they're not, and you don't put any hours in there, that means that could be problematic for you. So it really, that whether or not that clause works for you or not depends on whether the employee that you're applying it to is exempt from overtime or not, if that makes sense.
Makes sense. We have never had a reference to our policy manual employment agreements. Are you saying we can't enforce our policies?
Not necessarily. So it just, if you recall, I said earlier in the presentation, and I was referring to something else, but it's the same principle, that after a certain while, after a certain period of time, and there's no set period of time, it would be defined on a case-by-case basis by a judge or a third party, what have you. When something that is void in your employment agreement, it can be deferred to precedent as the thing that would stipulate whether or not it's an enforceable term. So if you never refer to your policy manual in your employment agreement and someone's worked there for six months, a year, what have you, then after a certain period of time, that policy manual will become part and parcel of your terms of conditions of employment, provided, of course, you have provided the employment agreement to the employee. It doesn't matter whether you refer to the employment, the policies in the employment agreement or not. If you haven't provided that employment agreement or those policy manual to your employee, they're not enforceable anyways. But if you were to the opposite side, if you were to bring somebody on board, and then after 4 months of employment, you terminated them based on a company policy which was not referenced in the employment agreement, it will be highly questionable whether you would get for cause, because you never made that policy a term and condition of employment, and they're only 4 months in. So precedent necessarily hasn't been established yet. So I always say that you should provide the policy manual in advance, but that's logistically, that's not always possible. What I wrote for our employment agreements, and I even think HSC law adopted a part of it, or a different version of it, but basically says at hire, you will be provided with a copy of our policy manual. You will have 14 days to read it, ask any questions, which implies understanding, and then you will have to sign an acknowledgement, or it'll be assumed that these policies, short of you asking any questions, that those policies and procedures become part of your ongoing conditions of employment. That's the way around it. So you can build in something in your employment agreement, which gives a buffer for you to provide the policy manual, and for your employees to read it and understand it, have the opportunity to ask questions. The opportunity to ask questions, if unasked, infers understanding.
From my understanding, if we ask someone to sign an updated employment agreement, we need to offer them something in return, consideration, i.e. vacation time, small raise, etc. Is this correct?
Correct. Yeah, we again, what we talked about, whenever for a contract to be binding, both parties have to get something out of it. When you're asking someone to sign an amendment, clearly there's something in it for you. It could be just the fact that it's enforceable because it changes something. That's still to the employer's benefit. The employee has to get something in exchange, in turn, for it to be enforceable, and that's more of a contract law thing as much as it is an employment law thing.
If there are changes required in the employment agreement, how do we handle previously signed agreements? And would an employee be in their right to refuse, or if it was like an amendment for constructive dismissal?
Yeah, it's a good question. Basically, if you have prior signed agreements, the last prior signed agreement you have is the one that's in force. When you offer a new agreement for somebody to sign it, they have the right not to. If you're unilaterally, if they agree on it, so be it. If they agree to consideration, awesome. Short of that, they have the right to refuse and stay under the terms and conditions of their prior employment relationship. This is where it gets a little bit, hellfire, if you will. The other option you have, besides providing consideration when you have that employee that doesn't want to sign a new employment agreement, is to provide working notice of the change. So what this means is, if you were to terminate an employee, right, you have the right to provide working notice or pay in lieu of working notice. Working notice can be considered of common law. So let's say you have an employee who's been there for 3 years, or say 4 years for the sake of ease. So they're at 4 full years. So they're entitled in most jurisdictions to 4 weeks and treated like a termination. They would be entitled to 4 weeks of working notice of the termination. Let's say you consider common law in there and you make it an even 4 months. Say in consideration of common law, we're going to give you 4 months working notice before the termination. In this case, you would say to the employee, oh, I understand you don't want to sign it. So what we're going to do is we're going to give you 4 months working notice that this employment agreement is ending. The current employment agreement you're in is ending in 4 months. At that 4 months, you will assume the new employment agreement, or you could consider those 4 months of working notice. We just provided you termination notice and we could see you on the other side, right? And that working notice of that employee, if you don't consider it as a person, you consider it as an arrangement. That working notice of that employment relationship ending, that employment in relationship or engagement ending is over, hence it's termination pay. It's harsh, especially when you get into longer term employees, because that working notice can be a couple of years. But for shorter term employees, providing them with, a month, 2 months of working notice, this employment arrangement ends in 2 months. You can either get into the new one or consider that your working notice and we owe you nothing. That's the other way to go around it.
Yeah, good. A few questions asking if this is going to be shared, and yes, this is being recorded and it will be sent out on Monday. So it's coming. Darcy, one question here was just said, will there be a checklist sent to us? I'm not sure if you mentioned some sort of employee checklist, but I just wanted to clarify that.
I did not, and I got in trouble for this. Kelly in one of our meetings gave me, because I keep on promising things on these, whenever we get into these webinars, in the course that somebody will ask about a form, and then I'll promise it, I'll say, if anybody wants it, let me know and we'll have it sent out. And then we get tons of emails and asking, where's this checklist or where's the FAF or whatever. So I got to stop. I can promise stuff. We did not offer a checklist, but certainly, if you are a client, you could just email in and we would provide you with a checklist about what you should have identified in an employment agreement. If you're not a client, by all means, email in, let us know. We will definitely get you a copy of that.
So you just promised.
You just
did exactly what you said you can't.
I know. Just that's what I'm saying. Don't tell them that I sent you, because like our writing and development people will get mad at me. And it's
all right. What can we do if an employee who does not have an employee contract, example, this employee has been here for 10 years. Contract was a handshake back then, but now there is nothing on file. What can we do to resolve this issue? And this is an issue that comes up a lot.
Yeah, all the time. Believe it or not, it's the same process as changing an employment agreement as getting them into a new one. So we have employment agreements that basically have a preamble on it, or context on it, saying this person has been employed since this date. So you have to recognize their prior years of employment. And then there's 4 points, but basically says you will agree to go into these stipulations. You've been employed since this date. You've not had a contract to date. However, in order to sign the following, and obviously it's an employment agreement, we're willing to give you this much. So for an employee of 10 years, and it actually was the exact example I used earlier, of an employee of 10 years, depending on other factors, the Bardell factors, which dictates how much common law they would get, let's say on average a month per year. So if you're going to have them sign an employment contract that has a termination clause that enforces them to the ESA, and keep this in mind, whenever you get somebody to sign an amended contract, or in this case, you get them to sign a new contract where they haven't had one before, you have to go through whatever has been changed, or in this case, go through the entire contract and explain what they're going to get with this new employment contract, but also what they could get if they never signed it. So you'd be explaining to this employee of 10 years that if we fired you tomorrow, not for cause, there's a potential that we might have to pay you, 8 to 10 months pay. But if you sign this agreement, we only have to pay you 8. Here's a raise. It's like, so you got to keep in mind consideration in a circumstance like that. If that was what you were trying to do, would likely have to be significant for that employee to agree with that. Like they would want some money up front to be able to say, yeah, I'll give up my money on the back end and lose that security. The other alternative, which I am a huge fan of, because of all of this, because of all the chaos around termination clauses, I am a huge fan of having termination clauses that are negotiated or provide more than the ESA or ESC benefit, right? Because then all of a sudden, all this language that is being challenged because you're trying to hold them to the ESA, if you're giving them more than what the ESA or the ESC provides, a lot of these court cases don't apply. So when you go to that 10-year employee and say, listen, we realize that under this language, you would only get, what we're offering you would only get 8 weeks. What we're willing to do is give you 2 weeks per year for every year of service, up to a maximum of this, right? that might be something that is more palatable for the employee of 10 years who's going to lose a lot of money if they sign this new employment agreement. So there's not only flexibility with the consideration, there's flexibility with what you could do in the clauses. And if you're going to do something like that, you definitely want someone like myself or my colleagues to review that, because there's still, you know, legal pitfalls when you're drafting a termination agreement or termination clause that provides better benefit.
Okay, we're getting to the end here. I'm going to try and get a couple more off. Our policy manual includes a termination clause under key legislated labor standard areas, and we recognize the importance of having a similar clause in our employment contract. What is necessary or beneficial to include the same termination clause in both the policy manual and employment contract? Why is it necessary or beneficial to include the same termination clause in both the policy manual and employment contract?
In truth, if it's only in your policy manual, the odds of it being enforceable in a court are kind of nil to slim. That's a term and condition of employment. It's an important term and condition of employment. Termination policies typically go into more general language about what substantiates or what would be classified as like a good termination policy. Will give you examples of what is such an egregious act that it would necessitate cause out of the gate. It would speak to the progressive discipline process and what brings you to termination. It would talk about all these different kinds of terminations that can be had, but it's not necessarily telling you what you're entitled to or limited to. That belongs in the employment agreement. You can have it in both places, most certainly, but if you don't have it in the employment agreement, the policy doesn't mean a whole hill of salt for the most part. There might be a judge or a third-party mediator that would see that another way, but I don't see how you can have something enforceable that, you know, is a meaningful term of employment that's not in the employment agreement and defer to an external or an internal document that would govern that, you know, meaningful term. I don't see it.
Okay, we got like 8 questions left. Okay, does the consideration also apply to renew and refresh in an agreement?
Depending on the type of change you're making. So with a renew and refresh, if it's like typical, if you're updating the employment arrangement to reflect current case law, changes to legislation, changes to job duties, et cetera, and you had that renew and refresh there, there's an understanding between the two parties that we're going to bring this up to existing, you know, the existing status of the employment relationship. If there's been major changes in case law, such as some of the ones that we've talked about, that would escalate even with the renew and refresh. The renew and refresh clause is not going to free you from consideration, right? That's it really comes down to whether the changes are meaningful. That, like, when you look at constructive dismissal, the bar to get constructive dismissal is 1, it's unilateral, but 2, the changes are meaningful. Same thing here. If the changes in case law or legislation were meaningful, which means it meaningfully changed the terms of the contract, the renew and refresh clause by itself is not going to give you that power to avoid consideration. It might give you some leverage, though, to force them to take the consideration if it's found. And that's speculation. That's not an HR fact. But renew and refresh clauses imply by the employee when they sign them that contract will be reviewed and updated within, you know, a 5-year, 3-year term period. So it would give you some leverage there in that regard.
Okay, well, that was great. We got 7 questions left, but we're just over a minute left. So again, Darcy, thanks for that. I hope you can get a little bit of a break in after getting all that information out there. Remember, this is being recorded. It will be sent out on Monday. Employment contracts is a big one. So obviously, if you're not a client, we would love for you to talk to us and become one, but just make sure you have employment and contracts in place. And like Darcy said, if you don't have an HR person who's reviewing them, you know, if there's changes out there, make sure you're getting them reviewed independently, you know, 3 to 5 years to ensure that they're still enforceable. So Darcy, thanks again for today. Really, really important topic. And I'm sure we'll do it again in 2025. Yeah, and that's it. So thank you, sir. We'll see you next time. We actually have another webinar next week as well. So I'll see you again soon.
All right, see you, Brett. See you soon.
All right, thanks a lot, guys.